He doesn't want to take responsibility for any of his actions. There's an excuse for everything.
Or message this little girl any of these messages.
And if he doesn't know.
A Texas courtroom. A defendant with a military past. Allegations involving a minor, alcohol, and digital messages that may or may not tell the full story. Every statement is under pressure. Every detail contested. Is this a case of misunderstanding or a calculated pattern the court can't ignore?
No, I mean, he doesn't know.
I was in the Air Force between 99 and 2004.
Parties, either you're saying you did this or you did not. I mean, that's what we're here for. I mean, if you want a jury trial today, we'll give you a jury trial today. But what you're here for is what the allegations are in the indictment.
That he wants to be the cool dad or to grant him the deferred adjudication probation.
My son is a loving person.
Mercy should be given to those who want to atone for what they did. That's not what he's here for. He's here to ask this court to give him a break because he's just, that's what he's.
Can I have parties announced for the record for the state?
Michael Villarreal for the state.
Melissa Christian for the defendant.
All right, and you, Mr. Guerra?
Yes, ma'am.
All right, Mr. Guerra, you entered a plea to count one of no contest on March 28th. According to the plea bargaining agreement, punishment is to be assessed at a cap of 16 years in the prison. There's a $1,500 fine. The state opposes your application, and there's to be no contact with the complainant in Chapter 62 registration. Any objections to the PSI report? State?
No, Your Honor.
Defense?
Yes, Judge. Specifically, Judge, on page 5, there's a narrative on the victim impact statement. The narrative is from the mother of the child in question. There are a number of statements that are hearsay statements, and quite frankly, there are a number of statements in here that are just flat not true.
Mm-hmm.
And so we would object to this narrative.
All right. State?
Judge, I believe that it's well within the province of the court to consider victim impact when assessing punishment. As far as the specific hearsay statements, I believe that they are statements made by the defendant, so it wouldn't be hearsay.
No, that's not. I respectfully disagree. This is actually the mother. This is not the victim. This is the mother making the statements, and she's basically repeating what she believes other police officers and other people had told her. There's a specific thing about 30,000 pages, which is not accurate. There's a number of things that are inaccurate that she is relaying that someone told to her. So those hearsay statements would not be this.
All right. So with regards to page number 5, the court is not going to consider page number 5 in sentencing.
Thank you, Judge.
All right.
We enter a Texas courtroom where allegations involve a minor, intoxication, and disputed digital messages. The defendant's military background clashes with prosecution claims of a troubling pattern. Is this misunderstanding or misconduct? As testimony unfolds, credibility, intent, and prior behavior come under intense scrutiny in a highly charged legal battle.
That she is relaying that someone told to her. So those hearsay statements would not be this.
All right. So with regards to page number 5, the court is not going to consider page number 5 in sentencing.
Thank you, Judge.
All right. I affirm the testimony you give will be the truth and nothing but the truth, so help you God.
Yes, ma'am.
All right. You can lower your hand, state your name for the record.
Mario Guerra II.
All right. Defense?
Mr. Guerra, could you tell the court what kind of educational background you have?
Yes, ma'am. I received a bachelor's degree in arts.
Do you have a military service history record?
Yes, ma'am, I do.
And which branch of the military is that with?
United States Air Force.
Okay. And when were you in the Air Force?
I was in the Air Force between 99 and 2004.
Okay.
Counsel, what I want addressed is the question that the state asked about Mr. Guerra, if it's true, allowing his son to blow in the toxilizer for him. And also with regards to the text messages and the stipulations where it says that Ethan was drinking Blue Moon or something of that nature.
Okay, Judge. Mr. Guerra, so specifically the court wants to know, did you provide alcohol to Ethan or this other child at any time?
Not to Ethan, to the other child, yes. The other child that I asked if I could purchase it for her because she was leaving and wanted to go hang out with some friends of hers.
And did you drink also?
Yes, before we even left. My son had asked if I could take him to see his ex-girlfriend at the time to say goodbye to her. And I let him know that I had just finished a beer and I wouldn't be able to take him because I would have to blow in the blower. He let me know that he would do that if he could see her one last time. And I told him, okay. I wanted to be the cool dad and just let him see his ex one last time. And so he went ahead and he did that.
And that was captured on camera, correct?
That is correct.
But on one of because I always read, counsel, I always reread everything. But on one of these text message, it says, defendant responds, victim tells him she is drinking MD, Mad Dog. Defendants asked victim what she got him, and victim said he should have told her, and she would have. Then it says, defendant stated, I'm here with the boys and drinking. Ethan's on that Blue Moon trip.
What does that mean?
That I don't know.
And counsel, I don't know if you want to show it to him. It's here. And that's a part of the steps.
Right here. Court wants to know what that's referring to.
And if he doesn't know, he doesn't know.
He recognizes him.
So you don't know what that's referring to?
No.
Okay. All right.
And are you involved with your mom?
Very much.
And what do you do for your mom?
Pretty much I'm the person who does everything for her. She's at that age now to where my father's not able to help out as much as possible. And my youngest sister, who used to be a part of the back and forth, has recently taken on the responsibility of my nieces from my middle sister, who was taken from us. And so she is not capable of taking care of my mom as much as we both used to. So my mom depends more on me than anybody else.
And Mr. Guerra, the court is going to be interested in knowing about these text message exchanges with this child.
I've repeated it to my attorney, but I never messaged this little girl any of these messages. And that is still something that I fought tooth and nail on. But we're here because of the fact that everything else shines a light as me being the person who did that.
Well, let's not talk in third parties. Either you're saying you did this or you did not. That's what we're here for. If you want a jury trial today, we'll give you a jury trial today. But what you're here for is what the allegations are in the indictment.
I understand what the allegations are in the indictment, but I don't think a jury trial would help me in any way.
Okay.
We'll pass the witness, Judge.
Any questions?
Just a couple, Judge.
Okay.
Very briefly. So you're telling this court, as part of which were contained in the stipulations of evidence, that you didn't message her, I quote, "You down to fuck me."
That is correct. The only message that I sent to her was after she messaged me saying, "I'm sorry." And I said, "For what? Did you mean to send that to Ethan?" That was the only message that I saw, and that was the only message that I responded to.
So you understand that we got these records from Instagram, right?
That is correct.
Right? From your Facebook profile or your Instagram profile.
That is correct.
Okay.
I understand that.
And that also says, "Let me know. I'll be happy to be beside you." You didn't say that either?
That is correct.
And that at one point you messaged that you're on the way. Did you read that message?
I read all the messages that were on there. The only one that I was aware of was when she said, I'm sorry. And I said,
The court debates a victim impact statement as defense raises hearsay objections. While the prosecution argues it's valid at sentencing, the judge excludes part of the narrative. This moment highlights the balance between fairness and emotional context. Should sentencing rely strictly on facts or include broader human impact considerations?
for what did you mean send this to Ethan?
And you're aware also, and I'm sure you are, and as you stated, that you were on bond for an intoxicated related offense and you had an intoxilizer in your car, correct?
That is correct.
And in those records that we provided to defense and you, that I'm on the way coincides with the time around with that breath where Ethan took the breath into the intoxilizer, right?
No.
Okay.
The timing that Ethan and I went was between 6 and 7.
Okay. So you're saying it doesn't coincide.
That is correct.
And you're aware that the intoxilizer also contained your GPS coordinates, right?
That is correct.
And lines up with what the victim says about what time approximately you were there.
My son and I were together. My son sat in the front seat. She sat in the back seat. And again, the only communication that I had was, did you mean to send this to Ethan?
Okay. So it seems like you have an excuse for all of your criminal history. So your theft in 97, and that one, I didn't steal anything, right? I was just there. I just am a victim of being present, right? Am I understanding that correctly?
Yes, sir.
Okay. So you're not guilty of that one, even though you pled to it. And then you're obstructed of a highway by intoxication. In that one, you're saying, well, my wife kicked me out. I had to drive. That's why you
No,
picked it up.
I am guilty of that.
Okay. But you make sure to say that Amy kicked you out, and then as soon as you're leaving, that's when you get pulled over.
I provided the story.
You have an excuse for basically all your criminal history here. How did you meet Evan?
The first son that I had met her, Ethan had invited her over to the house so they could hang out. That was just a brief hello, how you doing? Nice to meet you. And then they hung out in the living room area.
But you met Evan through Ethan, right?
Yes, sir.
And you communicated pretty frequently with Evan, both or mostly through Instagram direct messaging, right?
No, sir.
Okay, so you never talked about being like a mentor for him or anything like that?
That was in person. That was the second time that I had met Evan. She was suspended from school for an altercation that she had with other students. And as I was picking up my son for a doctor's appointment, I crossed paths with her and I met her mom for the first time. At that situation, I let them know that I had been working with Ethan, and not only Ethan, but other kids at the basis who were going through separation anxiety.
Okay, so you continue to try to serve as mentors for youth who are troubled.
Not necessarily troubled,
Okay. Who are going through issues.
who are going through issues that are affecting them in the classroom. Yes.
Okay. So that conversation you did have with Evan's mother in person.
Yes, that I had been working with the kids in my classroom as well as with Ethan regarding separation anxiety.
All right. Any other questions?
No further questions.
Any follow-up?
No, Judge.
All right. Thank you. All right. The court will hear brief argument. State.
Judge, we're asking, number one, that you deny his application. It's clear from the record that he's not a good probation candidate, regardless of what this offense is. He's demonstrated to this court that he can comply with not drinking while on probation, while had multiple violations, while on bond, even in this court. So that in and of itself should be enough to deny his application for deferred. But the facts of this case are egregious in the sense of this individual, an vulnerable individual. As you see in the indictment, it's listed as an AKA, is because the victim in this case is trans. As the court is well aware, individuals, especially youth, deal with a whole train full of stupidity coming their way. They have struggles already in their life. And this individual used that vulnerability of this victim. The facts are clear. He doesn't want to take responsibility for any of his actions. There's an excuse for everything. Mercy should be given to those who want to atone for what they did. That's not what he's here for. He's here to ask this court to give him a break because that's what he's just used to. He wants a break. We're asking that you deny his application and that you sentence him to the full 16 years because he deserves every bit of that time, and Evan deserves every bit of that time to feel safe from this individual. So we're asking again that you deny his application. You sentence him to the full 16 years.
All right.
Judge, briefly, I know the court's heard quite a bit. This is a delicate situation. It is a situation in which, upon review of all the evidence, Mr. Guerra felt that this plea was in his best interest. But make no mistake, he is definitely asking the court to grant him the deferred adjudication probation. I don't think anyone would be served by him going to prison for 16 years. I think that what Mr. Villarreal is representing to the court, I don't believe that's completely accurate. I believe this individual was transitioning after these events was because of what they are going through. This is a situation that Mr. Guerra got himself into, and I think that his family sort of relayed to you that he wants to be the cool dad, and it causes him to make some very egregious decisions. However, I do believe that he does have the family support. He has an excellent educational background. He is employed, as the court can see. This is an individual that will do well on probation. Any conditions that the court would like to put on this individual, he is going to be willing to do, and his family is going to be willing to assist him in successfully completing those. Any classes, any community service, any conditions. I know the court is fond of 90 meetings in 90 days, anything like that. This individual is going to successfully complete that. Thank you.
All right, defense, call your first witness.
Judge, our first witness is Ms. Betty Guerra.
All right, Miss Betty Guerra. All right, Ms. Guerra, can you raise your right hand for me, please?
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Betty H. Guerra.
All right.
Thank you, Judge. Ms. Guerra, could you tell the court how you are related to Mario Guerra?
Mario is my son, one of my 3 children.
Okay, and so you have 3 children, and where does he fall in line of your 3 children?
He is the oldest, and my middle child is deceased, was murdered
And when did that happen?
January 31st of last year.
Okay, can you hear her okay?
I apologize.
She just needs to take everything down, okay?
Yes,
All right, Ms. Guerra, do you live here in San Antonio?
yes, I do.
Okay, and are you involved with your son
Yes, I am.
and with his children?
He's here.
Okay, and could you tell the court a little bit about his character?
My son is a loving person, but he's too trustworthy, and he's put his family first, and he has a big heart and is always looking to advance in education, which with COVID has held him back, and is now working at home. Excuse me. He is responsible, and he puts his family first. He's been there for me when it comes to helping me out in situations with my
It's okay. Well, you can take your time.
certainly bad. I've been in remission for 11 years. And in the meantime, he hasn't been there for me. Before that, I was able to stop by the house after going to see the boys at practice.
Cross-examination intensifies as prosecution challenges the defendant's credibility using digital messages, GPS data, and prior history. The defense claims misunderstanding, but records suggest inconsistencies. The judge demands clear answers, forcing binary responses. The key question becomes whether repeated explanations strengthen credibility or signal a pattern of avoidance and responsibility denial.
Sports, which he hasn't been able to do himself. You can take it into consideration. The boys are at that stage where they need their father participating, and with graduation coming up for the oldest, he has a big heart and doesn't know how to not to get involved in helping other people, which sometimes gets him in trouble. He means well, but it's hard, to be human. He's not perfect.
And Ms. Guerra, may I ask your age?
I'm 69.
You're 69. And has your son been helpful to you as you've gotten up in years?
Yes. He's been there.
And with regard to your health issues, has he been helpful to you?
Yes, because he's a good talker. Gets me out of, being depressed myself. And I can come at him because I get back to him, which sometimes it's hard because I have to consider him also. And I'm going through.
Sure. And Ms. Guerra, you understand what Mario is charged with, correct?
Yes.
You understand what the charges are. Okay. And if the judge sees fit to grant him deferred adjudication, which is a type of probation, will you do everything you can to assist him?
Yes, most definitely. I will be there for you.
Okay. We'll pass the witness, Judge.
Any questions?
I just have a couple.
Yes.
And I just want to apologize about the health issues that you're having. I'm sorry to hear that. You mentioned in your testimony that sometimes Mario helping people gets into trouble.
That's that. And sometimes I feel like he helps us out and they don't need the extra help.
Okay. Are you saying that's what applies in this case?
No,
No.
no,
Okay.
no, this is just him. I do help ever since he was in the first grade. If he finished his homework, he'd get up from his chair and go help others.
I was making sure that you're not saying that he's in trouble in this case because he was trying to help out the victim. That's okay. No further questions.
All right. Thank you so much for coming in.
Thank you. I just-
Oh, no problem. I understand. I hope you
Thank
get better. All right.
We would call Amy Garcia.
Amy Garcia. All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand. Please make sure you keep your voice up so I can hear and the court reporter can hear. Could you state your name for the record?
Amy Marie Garcia.
All right. Defense.
Ms. Garcia, could you tell the court how you are related to Mario?
I'm the mother of his children.
Okay. And how many children do you have?
We have two boys,
And what are their ages?
17 and 13.
And what are their names?
Ethan Guerra and Julian Guerra.
I'm sorry. What's the first name?
Ethan Guerra and Julian Guerra.
And where do you live?
In my house.
Okay, here in San Antonio? All right. And who lives there with you?
My children and for the most part, Mario does.
Okay. Now, are you all together? Are you
In relationship.
yes, in a
No.
relationship? Okay. And whose house is it?
Mine.
Okay. And are you allowing him to live there?
Yes.
Could you tell the court how he is as a father?
He's helped me so much with them. He's always there for his children as much as he can be, given he has a single monitor. So
And can you tell the court specifically how he's involved with them?
He's always helping them, especially with my little one, because he's in sports. So he practiced with him outside. And our oldest is very much into music, so he helps him with getting him different instruments and showing him different things as far as playing them.
Is he a good dad?
Yes.
Okay. And
The prosecution urges denial of probation, citing bond violations and alleged exploitation of a vulnerable youth. Defense argues character and intent, but the court weighs accountability versus mitigation. The judge must now decide based on credibility, history, and evidence. This ruling carries serious consequences for both defendant and alleged victim.
could you tell the court a little bit about Mario's character?
Just like his mother said, he does care too much. He's he likes to help people. He's always wanted to be a teacher. That was one of his goals, and so he got his degree he got a teaching degree, and he loved that because he loved helping the kids and working with kids and also doing sports activities with them. So he was really involved with them.
And you are aware of the charges that are pending against him, correct? And to which
Yes.
he's pled, right?
Mm-hmm.
Okay. And Ms. Garcia, should the court grant him the deferred adjudication probation, will you continue to allow him to live at your house?
Yes.
Okay. And will you do whatever you can to assist him should the court impose any special conditions or anything like that?
Yes.
Is there anything else that you want the court to know about Mario?
No, he's just he does help. He helps a lot of people. He's very helpful.
How long have you known him?
Almost 20 years.
And when you learned of these charges, did you find them to be out of character for him?
Completely.
We'll pass the witness.
Just have a few questions for you. Were you together with Mario in 2018?
What date? What month?
How much, like, particular date? Were you in a relationship with him in 2018
Up until December.
up until December? Is that when he picked up his DWI that he pled to an obstruction of highway by intoxication?
Yes,
Okay. So you're aware that he was on probation for that offense, right?
that is correct.
Okay. Was he living in the same household with you at that time when he was on
Yeah.
probation?
Mhm.
Okay. And during that period of time is when he picked up this offense. Do you understand that?
Yes,
And during that period of time when he was on probation for an intoxication related offense, he was still drinking alcohol.
I'm aware.
Okay. And even while on bond for this case, are you aware that he's been continuing to drink alcohol?
I'm listening. Yes,
And are you aware that at the time that he committed this offense, he was under the influence of alcohol?
I wasn't aware.
Okay. So in the time that he's been on bond and on probation, and he's been residing in the same home as you, you've known him to continue to drink alcohol.
Much to my protest. Yes.
Okay. So despite you protesting, he continued to drink, right?
Without, yeah, when we were other.
Okay. Are you aware of on the night that this incident happened, Ethan is your 17-year-old, right?
That is correct.
He had Ethan blow into his intoxilizer so that he could drive.
No, I didn't know that.
Okay. Have you talked with Mari about this case?
To a certain extent, yeah.
And have you reviewed anything as far as talked about the evidence in this case?
Some of it.
Yes. And have you ever met the victim in this case?
No.
I'll pass it.
Any further questions?
No, Judge.
All right, thank you for coming in.
Mhm.
All right, Mr. Guerra, I want to let you know that I listened to everything that everyone has said. I've read all the letters that your counsel has presented. I listened to all the witnesses that were called, and I always internalize everything that I'm hearing from all parties because I always do my best to hopefully make the correct decisions. All right, in this case, I'm going to deny your application, find you guilty as charged of aggravated assault. There's to be no contact with the complainant in this case. Chapter 62 registration, $1,500 fine, time and money will run concurrent. And I'll sentence you to the 16 years. Did you review the document entitled trial court certification with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons.